Hello everyone, my name is Lalit Soni and you are watching Polity This Week by Drishti IAS. In this session, we will be discussing certain topics which are from the polity and they have been in news in the last week. Okay, so let's start. We'll be discussing these certain topics. So the outline of the video would be, we'll start with the safe harbor clause, then we'll move to the right to maintenance of Muslim women, then CBI probe and the general consent, then article 131 of the Indian Constitution that is related to your original jurisdiction of Supreme Court, and menstrual leave policies. We'll be discussing the context in which they have been talked in the news or why they were in the news, and then we will be going forward with the explanation or the static part of this. Okay, so let's start with the first one, that is related to your safe harbor clause in the, you can say, Information Technology Act. Okay, so there was this issue wherein a particular news agency has gone to court and they have said that the Wikipedia has some content which has been added by some user on Wikipedia, and that content is derogatory in nature, so they have gone for the defamation case against the Wikipedia. Okay, in that regard, this particular issue was in news. But when we are talking about Wikipedia is an intermediary. Okay, so when we are talking about the third man or the middleman, these are intermediary and they have certain protection which has been given in the IT Act. Okay, and that particular clause is basically the safe harbor clause. Okay, so in that regard, you can say Wikipedia can take a contention that the thing is, we are not responsible for such thing because the user, some other person, has updated that information on the platform. Okay, when we talk about the Wikipedia or other, these platforms which are there, or internet, you can say internet service providers. So there are these platforms which actually are there to facilitate a communication between audience and the user which are providing the information. Okay, so let's say there is Wikipedia, they have a page, or you can say there is a platform wherein any user can come and provide certain information. Okay, so the third person or any user has come, let's say user A has come and they have actually put certain information on Wikipedia with respect to the news agency over here, that is ANI. They have put some information over here. Now the thing is that information has been put by the user A and there is no role of Wikipedia over here, and that is why there is this the safe harbor clause, so that these intermediaries can be safeguarded. Okay, so that is there. Now let's talk about the news, where we will see what is safe harbor clause, what is there are other provisions which are related to it. So when we are talking about this safe harbor clause, that is being given in the section 79.2 and 79.3 of the IT Act, which lays down the requirement for the safe harbor clause to come into effect. Okay, so this section becomes important for you. That is, just remember that section 79 of IT Act 2000. So that would be sufficient for you. Section 79 of the IT Act, exemption from the liability of intermediary in certain cases. So these intermediaries are basically safeguarded from the liability which can be put on them. Okay, now this states that the intermediary shall not be held legally or otherwise liable for any third party information, data or communication link made available on the host or the platform. Okay, so let's say there was this person A, okay, and then there is this Wikipedia, okay, that is the host platform. On this particular platform, if A puts something, okay, and that is about, let's say, some X agency, okay, in that case, if this content which has been put by A on the platform or the wiki page of particular agency, in that case, if this particular information is having some kind of a lie or some kind of you can say statement which is basically derogatory to this particular agency, in that case, this particular platform or the Wikipedia or any kind of service provider, they won't be responsible. Okay, but certain check and balances are given in the next sections if we see. So we will talk about that later. Coming to the article section again, here you will see section 79 of the IT Act. It says that the intermediary shall not be held legally or otherwise liable for any third party information, data or communication link made available or hosted on its platform. Okay, so that is basically section 79. Now there are certain, as I told you, requirements are also there. The protection shall be applicable if, according to section 79 clause 2 subclause B. Okay, so according to this, there are certain conditions which has been put forward. Okay, the conditions is the intermediary does not in any way initiate the transmission of the message. Okay, if you want to avail this safeguard clause, or you can say safe harbor clause, in that case you don't have any kind of initiation on your part. Okay, So intermediary does not in any way initiate the transmission of the message. One thing, you did not initiate the transmission. Second thing is, you did not select the receiver. Okay, you did not targeted someone over there. So that is the thing is, you will not select the receiver of the transmitted message. Okay. Third thing is, you will not interfere with that or modify the information. Okay, so you did not modify the information contained in the transmission. Okay, so these are the three things. If you did not do all these three things, then you can avail the safe harbor clause. Okay, intermediary must adhere to the intermediary guidelines and the digital media ethics code, which came into effect in 2021. Okay, so these are the guidelines and the code which are there. The guidelines mandated that setting up of a grievance redressal mechanism. So basically, under these guidelines which has been implemented in 2021, there are certain procedure which has been given, and the guidelines has mandated that there should be a grievance redressal mechanism. Okay, when we are talking about this grievance redressal mechanism, there are certain officers should also be appointed. So here you will see there should be a resident grievance officer. Second, there will be a chief compliance officer, and then a nodal contact person. These three persons should be there in your organization, and if there is any kind of grievance, that should be conveyed to them. Okay, so these are the things which you should ensure that you have followed, so that you can get the benefit of the safe harbor clause. Okay, now in certain cases you will not be able to avail the safe harbor clause. What are those cases? Here in section 79 subclause 3, you will see that it states that the protection will not apply if the intermediary, despite being informed by the government or its agencies, does not immediately remove or disable the access to the material in the question. Okay, so let's say there was certain issue which has been arose, and because of which government has asked you to remove that particular content or disable the access to that particular content, and you did not do it. Okay, in that case you will not be able to avail the safeguard clause. Okay, so that is one thing. Second, additionally, the intermediary cannot tamper with any evidence of this message or content on its platform, failing which you would lose the protection under the act. Okay, now if there is certain issue, and the content is basically the evidence now. Okay, so you cannot go for with the tampering of that particular content. Okay, if you do that, then you will lose the protection of the safe harbor clause. Okay, moving further, rule 7 of the IT rules 2021 states that if an intermediary fails to observe these rules, this provision subsection 1 of the section 79 of the act, that is basically you can say section 79 subsection 1, okay, shall not be applicable, and the intermediary shall be liable for punishing under any law for the time being which is in practice. Okay, so basically if you have not followed rule 7 of the IT Act, says that if you have not followed the guidelines, in that case you will lose the protection of the safe harbor clause. So basically you will be liable then. Okay, so I hope that is clear. Now before moving further, we will just revise it. The thing is, here in the safe harbor clause, section 79 of IT Act, they talks about it, and it says that in certain conditions the intermediary will not be liable for any kind of action which has done by the third party. Okay, and there are certain guidelines or the conditions are given to avail the benefit of the safe harbor clause, and there are certain restrictions which has also been imposed. There are certain guidelines and the rules which has to be followed. If you don't follow them, in that case you will be liable under the law. Okay, now coming to the second part, that is basically your right to maintenance of Muslim woman. Okay, recently there was this case in the Supreme Court which was talking about section 125 of CrPC. Obviously you are aware that now when we are talking about the CrPC, that is not you can say enforceable, because after 1st of July we have new criminal laws. So if there is a case, you will have to follow the new criminal laws, but this case was registered before. That is why we are talking about the section 125 of the CrPC. Now section 125 of CrPC talks about the maintenance. Okay, now maintenance can be for the, you can say, spouse, then it can be for your kids and for your parents. Okay, but specifically speaking, right now the issue is with respect to the maintenance of Muslim women. Okay, now if let's see if there is a divorce, you know that when in India there are certain personal laws, there are specific laws are also there. So if there is a clash between the personal laws and the you can say the laws which are enforced like CrPC, etc., so people can move to the court, and court will decide on the matter. And recently there was this case wherein a person has actually illegally pronounced triple talaq and given talaq or the divorce to a lady, and that lady went to the court asking for the maintenance. Okay, the contention of the other party is that you cannot ask maintenance under the section 125 because you have to ask the maintenance under the 1986, which is 1986 act, which is there for the, you can say, Muslim women's right under the divorce. Okay, so that is there, that is the controversy. We'll be talking about that. Okay, now coming to the you can say issue and the right to maintenance of the Muslim woman. The Supreme Court held that the divorced Muslim woman can claim maintenance under section 125 of the Criminal Procedure Code 1973. Section 125 applies to all women including divorced Muslim women as well. Okay, now issue is that whether this section applies to Muslim woman or not. Okay, and Supreme Court has made it clear that it will be applicable to the Muslim woman as well. Okay, now when we are talking about the various law, there was this Sahabano case. When this case was there and there was this judgment in 1985, that judgment says that yes, section 125 can be applied to the, you can say, for the maintenance of the Muslim woman. Okay, but after that what happens, that in 1986 there was this government, and that government has come up with the law that was specific law for the Muslim woman, and they have gone for the divorce. In that case there was a law for the maintenance of that woman, and a specific you can say procedure was given under the law. Let's talk about that. Here you will see legal provision. If you talk about with respect to the maintenance, here section 125 of the CrPC provides maintenance for the dependents like wives, children and the parents if they are unable to maintain themselves and are neglected by the person with the sufficient means. Okay, so basically if there is a there is a person who is ignoring the maintenance of their parents, wives or children, in that case there is this section, that is section 125 of the CrPC, you can avail the maintenance. Now 1986 Act, Muslim Women Protection of Rights and Divorce Act. Okay, now as I told you, there was this Sahabano case. In Sahabano case, the lady goes to the court and asks for the maintenance under section 125, and Supreme Court actually gives that particular maintenance. Okay, after that the parliament goes for the enactment of this law, that is Muslim Women Protection of Rights on the Divorce Law. You can say that this was with respect to, or it was influenced by the personal laws. Okay, and here in this particular you can say law, the legislature has decided that the maintenance will be given to the Muslim woman as well in this particular law, and that maintenance will be given to her after the divorce, or you can say for the period of iddat only. Okay, now they have mentioned the provision with respect to the iddat period. We will talk about that. Enacted to protect the rights of Muslim women post divorce, include provision or mahar and the subsistence allowance decided by the first class magistrate. So basically provision of mahar. Mahar is the amount which actually was decided at the time of the contract which was signed, or when we are talking about the Muslim marriages, these marriages are basically a contract. So at the time of the marriage a contract was signed. Okay, and at that point of time amount of mahar is also been decided. Now when we are talking about the subsistence allowances or the maintenance over here, so in this particular case they have made a provision for the maintenance as well. And when we are talking about the pre-1986 Act, there was this section 125 which was applicable. In Sahabano case we have seen that. After that actually they have gone for the enactment of the 1986 Act, and in that particular act they have said that there will be a period of iddat for which maintenance will be given. Let's read it out. Section 125 of the CrPC is a provision that provides for maintenance to wives, children, parents who are unable to maintain themselves. We have talked about that. Then it applies to all religion and is not specific to any particular religion. Okay, so we can say that it is a law which is secular in nature and it is applicable to all, and following the article, you can say 14 and 15 of the Constitution, that is basically with respect to the equality. Okay, the section was made by the made legally available to the Muslim woman after the intervention of Supreme Court in Sahabano case. So in Sahabano case it was said that you can Muslim women can also apply for the maintenance under section 125 of the CrPC. Okay, where the Supreme Court held that the divorced woman, Muslim woman, was entitled to maintenance from her former husband under section 125 of the CrPC. Now coming to the next part, which is related to your 1986 Act. Here you can see the Parliament has enacted Muslim Women Protection of Rights on the Divorce Act 1986, which provided for a specific mechanism for divorced Muslim women to claim maintenance. Now here they have been talking about the restriction of the timeline. It restricted the maintenance period to the iddat period. Okay, iddat period is basically a time after the death of the husband, or you can say after the divorce with the husband. Muslim woman has to actually, before the remarriage, she has to observe a period of iddat. Most of the time, or generally it is 3 months. Okay, and after that only she can go for the remarriage. Okay, so that is the period of iddat. So the parliamentary law says that till the period of iddat you can claim the maintenance. Okay, moving further, iddat is a period usually of the 3 months which a woman must observe after the death of her husband or a divorce before she can remarry. After that, there was another case, that was Daniel Latifi versus Union of India case. In that case, they have actually increased the, you can say, timeline. They have said that not till the period of iddat but till the woman is basically remarrying. Okay, after that there was also another case, that was Shabana Bano versus Imran Khan case. Even in that case also it was same thing was said. You can say CrPC can be availed by the Muslim woman as well. Okay, current position if we see after this particular case which was discussed recently, in that case also it was said that you can say this particular position was reiterated, that 125 can be availed by the Muslim woman as well. The Supreme Court's ruling reaffirms that the Section 125 CrPC is applicable to all women, including those covered under the 1986 Act, thereby allowing divorced women to claim maintenance from their ex-husband. Okay, so basically right now the condition is that the Muslim divorced woman can also go for the availing the, you can say, Section 125 of the CrPC for the maintenance. Okay, so that is about the right of maintenance to Muslim women as well. Now moving further, next is general consent to CBI. Recently there was this case wherein CBI goes to state of West Bengal and West Bengal goes to Supreme Court that CBI cannot investigate in the state of West Bengal because we have withdrawn the general consent. Okay, now here West Bengal government has gone to the Supreme Court under Article 131 of the Indian Constitution, that is basically original jurisdiction of the Supreme Court. Okay, wherein any issue with respect to the between the, you can say, if there is a you can say any kind of issue which is between center and state, among the states. Okay, so in that case direct original jurisdiction of the Supreme Court will be applied, and under that particular article they have also gone to the Supreme Court. Right now our issue is that what is general consent to the CBI. Okay, so let's start with the discussion over here. See, Central Bureau of Investigation, first we will talk about that. So when we are talking about the CBI, that is a premier investigation agency in India, which is having a dual responsibility. One is with respect to the investigation of the grievous cases, okay, of the higher degree of the crime, and other is fighting corruption. Okay, so basically there are two jobs. One is if there is a heinous level of crime which has happened, or you can say grievous level of crime which has happened. So for that, and otherwise for the fighting corruption, these are the two, you can say, arenas in which CBI will be playing. Okay, the establishment of the CBI was recommended by the Santhanam Committee on Prevention of Corruption Act in 1962 to 64. That is the timeline of the committee. Moving further, it is not a statutory body because it was established by an order or the resolution of the Ministry of Home Affairs. So it is not a statutory body, and it derives power from the Delhi Special Police Establishment Act 1946, under which actually there are the powers of the CBI from which it actually derives the power. Okay, now nodal police agency in India that coordinates investigation on the behalf of Interpol member committees. If there is an international crime, in that case if the Interpol is involved, CBI will be the nodal agency over here. Nodal ministry is Ministry of Personal, Public Grievances and the Pensions. Okay, so this is about the CBI. Now coming to the what is general consent, etc. So I'll tell you, this content is written over here. I'll tell you the overall idea. As I told you, there is this special Delhi Police Enforcement Act, that is the you can say Delhi Special Police Establishment Act 1946, under which they have actually given the provision with respect to the consent by the states. Okay, now let's say there was certain case which was registered by CBI, and now CBI wants to investigate that case in a particular state. Okay, so now in that case CBI has to get consent from the state. Okay, state will give the consent. Consent can be of two types. One is your, you can say, this general consent. Now general consent means that CBI can ask for the consent and state will give you the consent, and state will say you don't have to ask for the consent again and again. You take this general consent, and as and when there is a case, you can come and investigate. Second thing is the case to case. If general consent is not given, then CBI has to go to the state every time there is a case and they want to investigate. Okay, so that is basically case to case basis one, and second is the general consent. Now right now the issue is with respect to the general consent. There are certain states which has given the general consent to CBI. West Bengal was one among them, and recently West Bengal has withdrawn it, but after that also CBI has gone and investigated in the West Bengal, and that is why they have approached the Supreme Court. Okay, So coming back to the article over here, the state give their general consent to CBI under section 6 of the DSP Act, consent of the state government to exercise of powers and jurisdiction. Okay, so in simple words you can say that without state consent, CBI cannot operate in the state as a police. Now CBI's position in this case, in this respect, different from the National Investigation Agency. When we are talking about the National Investigation Agency, national NIA does not require any kind of consent because jurisdiction of NIA is throughout India. Okay, so in that case we can say that NIA has a broader jurisdiction with respect to the CBI. Now what is the general consent? I have actually told you there is general consent and the specific consent or the case by case consent. So general consent is the, you know, once and for all, if the state is giving the consent, CBI can come and go investigate in that particular state, and if state withdraws that general consent, in that case from that particular date onwards, CBI cannot investigate in the state without the consent of the state. Okay, if let's say there is a case of past, that let's say 8th of July, and state has withdrawn the consent on the 12th of July. So in that case, since on the time of the commitment of the crime they had the consent, so in that particular case they can go and investigate over there from the date or 12th of July, the day they have withdrawn the consent. After that they cannot go for the investigation without the consent of the state government. Okay, so that is there. Moving further, withdrawal of the consent we have just talked about, and if there is a withdrawal of the consent, so and you have to investigate a case, so you have to file for a fresh consent from that particular state. Okay, CBI can continue to investigate the case in the state registered prior to the withdrawal of the general consent. If the case is registered prior to the withdrawal of the general consent, in that case CBI can continue to investigate. Now in contrast, if the CBI does not have the general consent of the state government, it requires to apply for the consent on the case by case basis, which we have seen. If a specific consent is not granted, if the consent is not granted, in that case CBI cannot investigate in that particular state, or they cannot use or utilize the power as a police officer. Okay, so I hope that is clear. Now coming to the next one, that is basically your period leave policy. So when we are talking about the period leave policy over here, you know that in any country or otherwise also world over, if we see globally, if we see, there is a 50% of the section of the population which are basically menstruators. Okay, and they are at a disadvantage because when we are talking about the process of menstruation, at that point of time they going through a particular process, they have different changes in the body, and there are certain difficulties which they actually face at that point of time, and in that particular 1 or 2 days of that process they feel various difficulties, they have to face various you can say issues, and that is why there is a demand for the period leaves, or you can say menstruation leaves. Okay, now there is a policy when we are talking about different states, and when we are talking about India, there are certain states which provide for such leaves, and when we are talking about nationally, we don't have such procedure. Okay, so recently we are talking about this particular thing because Supreme Court has given certain observations with respect to that. That is why we will be talking about it. So let's see over here. Menstruation leave policy in India, there are concerns that mandating menstrual leaves could lead to the discrimination against the women in hiring practices. Okay, now the thing is, Supreme Court in this particular thing, they have observed that if you are giving this particular leave, okay, so that will be beneficial for the woman and or the section of the society which are basically menstruators, and they will be part of the workforce. Okay, so that will give you can say potential push to the economic development, because there will be a huge workforce which will be entering into the workforce. Okay, there will be a huge section of the people that will be entering into the workforce. Okay, now if we are talking about the impact of giving such you can say leaves on the industry will no doubt when we are talking about the industry that is profit driven. Okay, they will be looking for the you can say more and more productivity, so there are certain companies which will not be happy with the idea of these leaves, because obviously they have to give a paid leave to a particular section of the society which are joining the workforce. Then they will not be comfortable with that. Okay, and there might be a you can say imaginary wall which will be created, which actually restricts such a section coming into the you can say mainstream workforce. Okay, so basically what will happen is that the companies or the recruiters, they might not be willing to let women enter into the workforce, because they know that they have to pay for the menstruation leaves. Okay, so that is the concern which has been observed by the Supreme Court. Now here if we see, the debate is centered around the balancing women's health needs with workforce productivity and equality. Okay, now current status, if we talk about, in India there is no national mandate, but there are various states and the private players which are giving such you can say paid leaves. Okay. Now coming to the next part, basically when we are talking about the legal framework, so there is Maternity Benefit Act 1961, which provides for the maternity leaves but does not specifically mention the menstrual leaves. Okay, so in that particular act we don't have provision for the menstrual leaves. Then coming to the labor laws, generally silent on the menstrual leaves, treating it as a part of the sick leave or the special leave. Current perspective, if we are talking about this, so we have already talked about the encourages women's participation in the workforce, could potentially discourage employment of the woman due to perceived inconvenience to the employers, cautions against the mandating such policies without considering the potential negative impact. If we don't consider the impact and we just give these particular, you can say, leaves, in that case the economy or the companies might have issues. So that is why we have to come on a common ground. Okay, now moving further, here state initiative if we are talking about, so Kerala was the first state to implement menstrual leaves policy for the government employees in 2017. Other states if we are talking about, so states like Bihar and Maharashtra, they are talking about it but they did not implement it yet. Okay, so way forward, so basically policy recommendation, the Supreme Court calls for the central government to consider framing a model policy for the menstrual leave, and awareness and education is important when we are talking about such initiatives. Okay, so that is about menstrual leave. Now coming to the last part, that is basically your Article 131, original jurisdiction of the Supreme Court. We have talked about the issue that West Bengal has moved to the, you can say, Supreme Court against the central government. That is the, you can say, context. And let's talk about the Article 135. So this is the original jurisdiction. Here you can say the Supreme Court is a federal court of India and possessing original jurisdiction to decide disputes arising between different units of the Indian federal system. Here you can say center or one or more states, if there is one side center and there is state or states. Okay, then center and any state on one side, and the one or more states on the other side. Okay, so that is another case. And third is between state versus state. Okay, in such cases they can move to the Supreme Court. Okay, so that is there. In the above mentioned cases, the Supreme Court has exclusive jurisdiction, which means that no other court of the country can try such cases. Okay, if there is a dispute between center and state, state and state, or center and one state on one side and other states on the other side, in that case only Supreme Court has the jurisdiction. Okay, moving further, here you will see how a few points needs to be noted over here, that in such disputes or under Article 131 original jurisdiction, only question of law or fact on which the existence or the extent of the legal right depends. Okay, on which you can say a issue of right has been discussed, or issue of law or the fact has been discussed, and not about the political nature. Okay, so such things cannot go to court if the issue is of the political nature. Any suit brought by a private citizen against the center or the state cannot be entertained under this article. Okay, so suit by a private citizen cannot be entertained under this, because only state government versus central government can go for such things. Now we'll go for the test. There will be five questions for you to solve. So let's see the questions. First is, what is the primary purpose of Section 79 of the IT Act? To regulate content creation on the internet, to exempt intermediaries from liabilities for third-party content, to impose strict liability on the intermediaries for any content on their platform, to monitor user activity on the social media platform. Okay, so you can attempt this and the answer in the comment box. Second question, which Section 125 of the CrPC provides for the maintenance of? Okay, so there are four options which are given. One is divorced Hindu woman, divorced Muslim woman, legitimate and illegitimate child, and all of the above. So you have to select on which of the following sections the Section 125 of the CrPC will apply. Okay, moving further, which act governs the functions of the CBI? Indian Penal Code, Code of Criminal Procedure, Delhi Special Police Establishment Act 1946, Prevention of Corruption Act 1988. Okay, then next question number 4, which Indian state becomes first to implement a menstrual leave policy for government employees? Maharashtra, Kerala, Tamil Nadu and Karnataka. We have talked about it. It is a simple question. Now last, that is question number 5. Which article of the Constitution of India is related to the original jurisdiction of the Supreme Court? Article 13, Article 226, Article 32, Article 31. So you have to choose the correct option and reply in the comment box. With that, I would like to take your leave. If you have not subscribed the channel, please subscribe it. Have a nice day. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.